You said you missed me. Why are you hesitating? I was expecting to hear you say, "Oh yes, welcome back. We missed you."
Yeah, we missed you. And it's good.
It doesn't hold any water anymore. I mean, I had to bring it out of you. You would have said it on your own, but it's all right. Okay, so Barrister Uche is here, and together we will be on Probono today. As always, we begin by talking about something, of course, that has to do with legal matters, and afterwards you get the opportunity to call in and interact with us. Especially with her, as you'll be asking her any question at all. How does it feel really to know that, well, I'm on this seat right now, anybody can just ask me any question? How overwhelming is it? Is it overwhelming, or it's just, like a piece of cake?
It's not overwhelming. It's not like a piece of cake
it's a piece of cake. No, as far as you are concerned, it's like a piece of cake.
No, it's not.
So please, if you are listening, any legal matter question you have, whatsoever it is, just make it sound very difficult and then ask her the question. She will answer you. Trust me, I know what I'm saying. Okay, so Barrister Uche will be giving us some insight into alternative dispute resolution.
Yeah.
Alternative dispute resolution. So what is ADR? That's how people are calling it in a very short formish way.
Yes. ADR, alternative aka alternative.
Yeah, I like the AKA.
Alternative dispute resolution are the models that, simply put, in one sentence, it is the models of settling dispute out of court.
Okay.
Now, basically, we realize that in our everyday interactions as humans, in whatever sphere, or in the home, at the office, and the workplace, internationally, domestically, economic, whatever kind of relationships or interactions that people engage in, many of the times disputes are inevitable. People have disagreements arise from many of these interactions, and that is why we have dispute settling models put in place, especially where we have the most common one, which is litigation, where people say let's end up in court and all of that. Now, these are what we are used to. However, we'll find out that a lot of things ending up in court is not always as easy as it seems from the outside. On the outside,
what's difficult about it?
Well, because it's not as if it is difficult per se, but it is not easy per se also. It's very expensive, it's very time consuming, it is fraught with a lot of technicalities, it has a lot of you expend a lot of energy going to court, you spend a lot of money going to court, getting there when you are in court, anything may happen, apart from the fact that you can spend years arguing in court. Now,
so why suffer and go and study law and become lawyers and have court rooms and judges and everybody, only for you to sit here and tell us that it is expensive, it's time consuming, it's this and it's that, so many disadvantages?
No, it's not. It has a lot of advantages as well, but we are looking at the
in comparison to ADR. ADR is like better. That's what you're saying.
Well, ADR has a lot of advantages. Now, for the parties in the dispute, now where parties are involved in this dispute, we look at what will suit them, what is better for you in the long run. How does this help you, or help the situation, or help the circumstance in which you find yourself? Which is why we always say, or we all know, whether we'd like to agree or not, we all know that ADR, the various models of alternative dispute resolution, can be tailored to suit the specific requirements of the individual parties to the dispute. So that is why increasingly, and in recent times, it has increasingly focus is being shifted from the courtroom and from litigation to all these other alternatives, to find out to try to develop or aid parties to reach a resolution without actually going to court and spending time and taking all of that. Now, many of the times too, when you think about why ADR, you find out that sometimes the course of action is actually not worth it. If, for instance, someone is owing me like 20,000 or even 50,000 or 100,000, and then I try to looking for a way to recover the money, or the course of action, probably you cost me damage worth that amount, and I just feel that yes, I deserve a remedy. How well will he pay me to go to court, institute my matter, probably get a lawyer? Of course, I will pay his fees. I will pay for all the other miscellaneous fees, do all of those, go to court day in, day out, and then try to get justice. At the end of the day, you find out that you are even losing more than you would ordinarily have gained. Secondly, many of the times too, most of these disputes have a very sensitive nature. If probably marital issues.
You shouldn't take marital issues to court.
No, I'm not saying you shouldn't take. I'm trying to say that
I'm trying to understand
you too. Examine these different circumstances that will probably be of a higher advantage to the party. If, for instance, you have a course of action and then you end up in court and spend 18 years, ADR will never take as long as that. And then you find out that many of the times when these matters end in court, it is not just what matters. Judges are bedeviled with a lot of matters they have to attend to. And so you have a large amount of cases that would take a long period. And then, of course, I always believe, it is my personal belief, that you can't end up in court and still remain friends. ADR has a way of maintaining and preserving relationships, where relationships matter, where the relationship or the interaction between both parties is of crucial importance, then I don't think that can be maintained. So it reduces acrimony, it reduces antagonism, it reduces the fight and the stress, and tries to preserve this relationship as well.
So if for any reason I take you to court now, we will not remain friends?
I doubt we will.
You see me as an enemy.
I mean,
what if I still choose to?
I'm not trying to say that. I'm not trying to say that everybody that ends up in court don't become. But it's, you go to court.
There's just something
practically
there's
fight.
Something that comes along with.
There is something that
you took me to court.
Yes,
that kind of thing.
When you end up in court, it's like the battle line is drawn.
Yeah.
Since we cannot come to an agreement, then let's go to court and settle. And it's very rare. I'm not trying to say that it's not possible.
What if one party is willing to try ADR and the other says no?
Well, then maybe they might have to end in court.
Okay.
Yes, because you can't force a horse to. If he decides that the matter must end in court, then it means that both of you do not have a middle course. So you want to get to court, and you can't force ADR on an unwilling party.
Okay, so if we're not doing litigation, what are these advantages? You have already started on that line. What are these advantages of ADR, alternative dispute resolution?
Like I said, it is less expensive. It is less expensive. It helps to preserve relationships. It helps to maintain the privacy of both parties. Because the moment you end up in court, you are in an open space. You trash out your issues in the public glare. You know, sometimes the media is even there to cover the proceedings and all of that. But ADR helps to preserve your privacy, if that is of utmost importance. For instance, like I said, in matrimonial cases, sometimes these issues are very sensitive, and it's not always proper that you go to court and spread your dirty linen, if I'm permitted to say that. Now, most times, because of the sensitivity of these matters, it is encouraged that persons or parties should consider ADR. Like I said also, it preserves relationships. It reduces antagonism between both parties. At the ADR table, parties don't see themselves as enemies. They see themselves as persons, individuals, or organizations who are looking for a middle course, who are trying to give concessions and agree on the path to forge on a pathway to forge ahead. Now, it reduces the acrimony or the tension. Most times, the setting is less formal, so you are better equipped to express yourself very well.
So you can meet in an individual's house or any other place outside.
Where parties agree. Yes. anywhere, they have, most of the times too, they have a right to determine the outcome of the whole procedure.
Who do you need for an ADR?
It depends on the model. Now, there are 4 models.
Okay.
4 basic models. There are other models too. But in ADR, basically, there are about 4 of them. We have conciliation, we have mediation, we have arbitration, and of course, negotiation. Now, these different models have their different characteristics, and they are applicable. They are tailored to suit certain kind of disputes,
okay,
so to speak.
So, depending on what kind of dispute you have, it could be negotiation.
Yes,
you
like
need someone to help.
For instance, now, okay, like today, we're going to be considering 2 of these models. We're going to consider mediation and negotiation, and then tomorrow we'll take arbitration and conciliation. Now, we're going to look at how different these models are, what are their unique characteristics, and how they can help parties to a dispute to arrive at a middle course and arrive at an agreement and forge ahead.
Okay, we will listen to that after the break. Do stay with us on Human Rights Radio.
Your right, my right, our right. Everybody's right is protected. Human Rights Radio 101.1, redefining broadcasting.
This is to inform the general public that the activities of scavengers, also known as Babambola, is prohibited within the Federal Capital City. Their activities are henceforth restricted to the area councils. Residents of the Federal Capital City are advised to be vigilant and report any suspicious activities to law enforcement agencies. Together, we can make Abuja the city of our dreams.
Awidna akugna aza vien kezinege tuntun aza mbatun aya unavidan kuluna kobege baba bola atela chebaje ukizinde unkoi tinya kola ka hae abatun kola gbojin nara kan si vien ba lo mutna ekizinde ozana wa sasatu vidan kulu wotna aba wa api aga otata agna kizinda mbasasalo ge balaweka na zaipia da na azalaba sasalo kinzinege balawepi na ja zaipia bakara na bana banwa ba tabashiba agabatata na wode ya mi kinzinne ko na ba agwa abeji I would never embark me no city atutnu jina pokoge Federal Capital Authority Administration.
èyí ni láti kéde pé ojúṣe àwọn sagolo sapáànù tí a mọ̀ sí Babambola ti dó nílùú Àbújá àti ìjọba àbílẹ̀ mẹ́fẹ̀ẹ̀fà bí ọwọ́ sìnkú àwọn agbófinró bá wá bá ẹnikẹ́ni nínú wọn yóò fi ojú ba ilé ẹjọ́ o. ẹ̀yin olùgbé Àbújá ẹ yára tètè tẹ́tíléko tẹ́ bá rí ẹnikẹ́ni tí ń yọ́lẹ̀ ẹ̀dà tí kò tẹ̀lé òfin tó sì ń sagolo tí ń sapáànù ẹ tètè fi tó àwọn agbófinró létí. àjọṣe wa ni o láti mú kí olú ìlú yìí dùn ún wò kí ó sì dùn gbé pẹ̀lú ìrọ̀rùn. ìkéde yìí wá láti iléeṣẹ́ ìjọba olú ìlú yìí ìyẹn Federal Capital Territory Administration.
Aha! Kéku ló gbọ́ kó yá àwí fún toko kádùn ó gbọ́ kóró fún òbẹ̀ pé ìjọba olú ìlú yìí ń fi àsìkò ìran gbogbo olùgbé ìlú yìí ní etí o pé ìjọba kò fi àyè gba àwọn ọkọ̀ tí kò dára kẹ̀kẹ́ nàpẹ́ẹ̀bù ọ̀kadà alùpùpù àti àwọn ọmọbìnrin tí ń ṣiṣẹ́ ìgbélépawó ìyẹn àwọn aṣẹ́wó nínú ìlú Àbújá o. mọ́ gbàgbé pé àwọn amúnisínkùn ìjọba ń bẹ láàrin ìlú bí ọwọ́ wọn bá bà ọ́ ajẹ́pọ̀ orugi oyin nìyẹn o. káwí fún ni ká gbọ́ ìlóyọmọ adarí hurun ṣèbí ká sọ̀rọ̀ fún ni ká gbà ní ìyọmọ ẹ̀dá èèyàn. gbọ́ ohun tí ìjọba olú ìlú yìí ń sọ fún gbogbo wa kí ìlú Àbújá kí ó lè dùn ún wò kí ó lè dùn ún gbé fún gbogbo wa. dídára olú ìlú yìí àjọṣe wa ni o. jẹ́ kí èmi àti ẹ jẹ́ olùgbé rere. ji ohere a echetara ndị bi isi obodo anyị bụ Abuja mkpa ọ dị idobe iwu tụmadụ ka o si gbasata okporo ụzọ n'ebe obibi na-ezighị ezi. Biko mara na enyela otu task force nke minista hibere ikike ịhụ na iwu nke mechibidoro adịgboroja ụgbọala ọbụla eji arachapịọm pụtara ihe. Ha ga-ahụkwa na akwụsịrị kpamkpam iji ọgbatumtum maọbụ ị na-aga ebugharị ndị mmadụ n'isi obodo anyị bụ Abuja. Otu a ga-ahụkwa na ha gbochiri ndị keke ma mawapụtakwara ha ebe ha ga na-agba na mpaghara isi obodo anyị. Ha ga-ekpochapụkwa ndị akwụna na ụmụ mmekpa ahụ ndị ọzọ dịka ịtụ mgbere mmadụ, ire ọgwụ ike nakwa iwepụ ma kurie ebe obibi ọbụla na-ezighị ezi. Otu a ga-ahụ na ewepụrụ ọdụ ụgbọala na-ekwesịghị ekwesị n'isi obodo anyị. Biko ka anyị jikọọ n'aka ọnụ wulite FCT ka ọ dị ka anyị si chọọ ya. Ndị aka ga-akpara dara iwu ndị a ga-eji anya ha hụ ntị ha, bụrụ ezi nwa amaala, tobe iwu ala anyị.
Ana sanar da dukkanin al'ummar birnin tarayya Abuja da ku kasance masu bin dokoki sawu da kafa, musamman ma ta fuskar dokokin hanyoyi da na kafa guraren kwana ba bisa ka'ida ba a birnin tarayya Abuja. A kuma sani cewa har yanzu dokan nan ta hana amfani da tsofaffin motoci a matsayin taxi, haka zalika kananan motocin bus da kwasta, tare da hana sana'ar acaba a cikin birnin tarayya Abuja. A kuma tabbatar da cewa an bi dokar sana'ar acaba a guraren da doka ta amince, tare da tabbatar da bin dokar hana karuwanci da yawon banza a birnin tarayya da sauran laifuka kamar tu'amali da miyagun kwayoyi, kafa tashoshin motoci ba bisa ka'ida ba da dai sauran laifuka iri daban-daban. Hakika duk wanda aka kama ya karya doka za a hukunta shi. Mu haɗa hannu domin gina birnin tarayya Abuja a matsayin abin alfaharinmu.
Are you living around Jahi, Utako, Kado, Life Camp, Warimpa, Katampe, Wuse2, Mabuchi, Kado Kuchi? If you are, do not miss this awesome opportunity to get your child enrolled in our purpose-built school. Our fees are unbelievably cheap for what we offer. Register for daycare, nursery, and primary at Oscar International Academy, located at Jahi 1, beside Platinum Plaza, by Mabuchi Ultra Modern Market, Abuja. Also available is a fun-filled educational plus skill acquisition summer program. For more inquiries, please call 081-01-17-2885 or 070-8202-8220. Oscar International Academy, the perfect grooming ground for your kids.
There is an opportunity of getting employed on Project Smart Jobs and earn up to 300,000 naira monthly.
Really?
Yes! The National Institute for Hospitality and Tourism, NIHOTOUR, has partnered Consolidated Alliance on Project Smart Jobs.
Project Smart Jobs?
Project Smart Jobs is an online employment training platform that gives you requisite training plus empowerment seed fund up to 1 million naira as startup capital.
Seriously?
Yes! 1 million naira to buy and sell deals on Smart Jobs mobile application. For more information, visit www.nihotour.gov.ng and click on Project Smart Jobs. To register, visit www.smartjobs.ng or call us on 081-8557-8887 or 081-8557-8888. Take a bold step and visit us now.
A yayin da damuna ta fara kankama, an shawarci al'umma da su guji bata muhalli wanda ke iya jawo ambaliya. Zub da shara ba kan gado shine makasudin babbar ambaliya a birnin tarayya Abuja. Saboda haka kar ku zub da sharar ku a magudanan ruwa. Bugu da ƙari, an shawarci al'umma da su kiyaye yin gine-ginen gidaje a hanyoyin ruwa wanda yin haka kan iya jawo rusan da zai laƙume rayukan al'umma da dukiyoyinsu a lokacin damuna. A koda yaushe ku kasance mai yin abin da yake daidai. Wannan sako na zo muku ne daga hukumar birnin tarayya FCTA.
ebidola a na-adọ ọhaneze aka na ntị ka ha gbochie ma kwụsị akparamagwa ga-ebute mmiri ọdụdọ na mbuze dịka iwufu ahịhịa n'ime mmiri na-asọ asọ ya na ịtụnye ihe n'ime gota. A na-emekwa ka ị mara na iwu ụlọ n'ebe na-ekwesịghị dịka ụzọ mmiri nwere ike ịkpata ịtụfu ndụ ndị mmadụ n'efu ya na ihe nweta ndị mmadụ ịla n'iyi. Mee ihe kwesịrị dị mma. Ọ bụ Federal Capital Territory Administration FCTA na-ezitara gị ozi a.
Gẹ́gẹ́ bí a ti mọ̀ wípé àsìkò òjò láwà, èyí ni láti sọ fún gbogbo ènìyàn láti yàgò fún ìwà ìdọ̀tí, dídà ìdọ̀tí síbi tí ò bójúmu tí ó lè fa omíyalé, àgbàrá ya ṣọ́ọ̀bù. Dídà ìdọ̀tí síbi tí ò bójúmu tàbí òpópónà sì jẹ́ ohun kan gbòógì tí ó ń ṣokùnfà omíyalé, àgbàrá ya ṣọ́ọ̀bù ní ìlú Àbújá. Ẹ má ṣe da ìdọ̀tí sínú gọ́tà tàbí ọ̀nà tí ìjọba ti pèsè sílẹ̀ fún omi láti gbà kọjá. A tún fi àsìkò yìí sọ fún gbogbo olùgbé FCT Àbújá láti rí dájú wípé wọn ò kọ́ ilé sí ọ̀nà tí omi ń gbà kọjá. Èyí lè ṣe okùnfà pípàdánù ọ̀gọ̀rọ̀ ẹ̀mí tàbí pípàdánù ohun ìní ní àsìkò òjò. Ẹ ṣe ohun tó tọ́. Ìkéde yìí wá láti àjọ FCTA Federal Capital Territory Administration.
As the rainy season begins, the general public is hereby advised to avoid environmental practices that could cause flooding. Indiscriminate waste disposal has remained a major factor causing flooding in the FCT. Do not throw your garbage into gutters and drainages along waterways. Residents are also advised to avoid building houses around natural waterways, as this could also lead to loss of lives and property during the rainy season.
Do the right thing. This message is from the Federal Capital Territory, FCTA.
Human Rights Radio.
Join our diverse team of legal experts as we provide education and guidance to you, our listeners, on a broad array of issues raised by the modern legal landscape, absolutely free on Probono Chambers, airing on Human Rights Radio 101.1 FM, redefining broadcasting.
Human Rights Radio.
Thank you for staying. It's 10:30 a.m. Pro Bono Chambers continues. Today we are looking at alternative dispute resolution, aka, according to Ina's barrister, aka ADR. Before we went on that break, you did say that we're going to focus on two of the different models, which is mediation.
Yes, which is negotiation and mediation. But before then, I must state that alternative dispute resolution has been a part of us for a long time. Yes, of course, focus shifted from this to litigation, which looks like a more formal,
corporate,
and more
serious.
Yes, more
maybe
formal.
Scary.
Not scary.
Because some people may end up in jail. Is it not scary?
Well, yes. Well, now
it's
a more formal institution.
In ADR, is there anything like such punishments?
Yeah. Well, yes. To a large extent, I don't think so.
Okay.
I doubt if there is. Now, but the point is, it's been a part of us for a very long time. And of course, like I was saying, focus shifted from ADR to the more traditional form of settling disputes, which of course is litigation. Now, the courts are there as an institution created by the state, and of course, the judges sit over these matters and attempt to settle these disputes based on the evidence before them. But you find out that even before this system is an offshoot of the colonial experience we had as a nation. But before even colonialism, we had traditional means of settling disputes, both in the local communities, within families, and even both intra and inter-communal clashes or disagreements.
Okay.
Now, you now try to understand the fact that this has been with us, notwithstanding the fact that, yes, maybe we shifted focus, but it is a part of us. It is not foreign to us as Nigerians and us as Africans. So what we're trying to say in essence is that it is a system that has was in place and even helped us a long time ago, there used to be nothing like the courts, and people had a way of effectively settling their disputes, reaching a consensus, disagreeing to agree, and of course maintaining the relationships without antagonism, without tensions, without acrimony, and without hostility. So all of these models were even there before. Now, when we come to talk about the different models of alternative dispute resolution, one of such models is mediation. Now, what happens in mediation is it is a process where the parties, either both or all of the parties, where there are more than two parties, come together and try to reach an agreement with the help of a neutral third party. Now, in this case, there is a third party to the dispute who has nothing to do with the dispute at hand. He comes in as a sort of a middleman for both parties and tries to help them examine the dispute, raise issues around this dispute, and then find a way of helping them to find a way of
coming to an agreement
or reaching an agreement.
Okay, so if you and me, we have an issue. Yes. I have a friend, but this friend does not know. His hand is not inside the whole dispute, but then he's my friend or she's my friend, and she is coming in as a mediator. Is that the person cannot?
It has to be a neutral person.
So it's not just you not having anything to do with it, but you also should not have anything to do with the parties, either of the parties.
Yes. Now, when this neutral person comes in, all he doesn't try to advise the parties. His job in mediation does not include advising the parties. His job also does not include trying to examine what is right or wrong. You don't try to pinpoint that, oh, this party, you were right in taking this step, or you were wrong in taking that step. No. But basically, all you do is to try to guide the parties to follow all the steps and reach an agreement. Now, it is not binding on both parties. Any of the parties can decide at any point in the mediation process to walk away. So it is not binding on them. However,
this is still sounding very formal, if you ask me. That's not what is obtainable. For instance, in a compound, Mama Emeka, Mama Uchi having issues, and then they call, maybe the landlord also lives there, and then they call landlord to come and settle it.
The landlord might be a neutral party. He has no affiliation to you.
I mean, he knows them both.
Yes, he could not, of
Which
course.
is one of the reasons for some of us will say, this person knows these people, he understands the situation, perhaps he'll be the better person to handle the situation. And in most cases, I hear where they'll say, but Mama Emeka, you're the one that is wrong. You would have... Yeah, I'm saying this because you mentioned that you should not...
Yes, well, in mediation...
That is not necessarily taking sides. Perhaps this person
is taking
just...
sides.
Yes, but you're pointing out and saying
a referee.
You were wrong here.
It's just like a referee.
A referee points out where someone goes wrong, and that's why you get a yellow card or a red card.
In mediation, no.
Why not?
Because you are not trying to raise dust.
You're not necessarily raising dust, but you're also making especially the one on the wrong side, to understand that you are wrong and make way for peace.
It's not for you. Okay. It's not for you, the mediator, to point that out. Who is wrong? The parties will eventually.
How?
There is a process that your job is to guide them, basically, not to advise them. So in the process, you allow them vent, you allow them make all the I let the parties point at each other that you were wrong or I was wrong or all of that. But it is not you. It's not for you, the mediator who is sitting in the middle, to say now be the one who points the accusing fingers and says you were wrong or not. Now, basically, what you do there is to guide them, not to advise, not to judge, not to determine the outcome of the process. It's not your job. It's not the job of the mediator to also determine the outcome of the process. That will be done by the parties themselves.
So you're saying I cannot be a mediator?
How so?
Because if I were to be a mediator, I would say, Uche, you should not have said this.
Well, maybe you would do. Now there are other models that allow that. Okay, no, but in mediation, that's why we're focusing on mediation. Okay. Yes.
Okay. So there's hope for me then.
Yes, there is a job for you somewhere in the long run.
All right. So let's get to the next one.
Okay, so that's now before I go to negotiation, that is now in mediation, it's more appropriate for in disputes that are very sensitive, or where it's important that relationships are preserved, maybe between family members or business partners, or where either of the party is a very probably sensitive person, then it's important. But it's not advisable in disputes where one person has a higher bargaining power than the other person, maybe between a boss and his employee, or between in a master-servant relationship, so to speak. Now, mediation is usually not the best option for such kind of disputes. Now, when we talk about negotiation, this is very, very, very common. We negotiate all the time in different spheres. We try to give and take. You make concessions and all of that. Now you try to shift grounds. You give me this, I give you that. You do this, I do that. Now that is very common. Now in mediation, in negotiation rather, the parties undergo the process themselves or through professional negotiators. So basically what they do is that they try to shift. There is no middle person this time around. There is no middle referee sort of. There is no judge. There is no anybody. This time around, parties have to do the negotiating, so to speak, or the concession in themselves. You try to shift grounds, you try to make adjustments in your opinions or in your arguments, and at the end of the day, they have a way of finding a middle course. Now, negotiation could be informal, where it is between probably family members, neighbors, or friends, or so to speak, where the relationship between those persons is less formal. It could also be formal, where it is between large corporations, agencies, communities, and all of that. So basically, at the end of the day, what all of these models seeks to protect or seeks to achieve is a speedier and faster, less expensive access to justice, devoid of all the delays and all the costs and all the tension and all of that. It seeks to give individuals or organizations or corporate or even countries an easier access to justice, while as well preserving this relationship. Now, it's also important to know that in the rules of court now, some of the rules of the court, before you file a matter in court, you must show to the court that you have attempted to alternatively settle this dispute, and that probably parties failed to, or parties refused to. Now, the agreement of where parties undergo alternative dispute. Now, alternative dispute resolution methods are also supplementary to litigation. So sometimes, even while parties are in court, they can decide midway that, no, we don't want to continue in court. We want to go back outside and settle this dispute, which is, settling out of court, which is highly advised. Every judge,
so the judges will not feel disappointed and say, allow us to finish what we've started.
No, with all pleasure.
Like,
please go and settle, because you are helping the system. When you agree to settle, you are helping yourself and you are helping the system. By the time you withdraw your matter from court and you go and settle, that's one case less for the court to bother about. So, and then the decisions arrived at in this at the dispute resolution table could be also be adopted by both parties as their consent judgment. So the court can also accept that and say, okay, fine, you guys have agreed, you both have agreed on this. We adopt it as your judgment, and then it will be binding on both parties.
All right, good. 08189991011. That is the number to call. Feel free to do that, and let's get your thoughts on Probono Chambers this morning on Human Rights Radio 101.1 FM. Good morning.
Yeah, good morning to you.
You're welcome. What's your name?
Prince Alex.
Prince Alex.
Yeah.
Okay, please go ahead. Okay, I said go ahead. I didn't say to drop the call, but I don't know what happened. You can call right back. 081 89. All right, let's see who's here. Hello.
Hello, good morning.
Morning, you're welcome. What's your name?
Yeah, I'm Jukes from Airport.
Jukes.
Yeah. This topic, there's a clarification I really need. If, for instance, the case is already in court, and the court maybe asked parties to go for arbitration. That area of arbitration is what I'm not so clear. Is it same like this APR? Because most times the court also assign a judge, whether a retired judge or something, to supervise the arbitration process and report back to the court. And most parties at times are not always comfortable with it. Is it within the court power to send parties for arbitration, or is both parties coming together to agree that they want to go for arbitration and all that? So it's still, I'm not so, I don't have a proper understanding on that.
Okay.
With regards to negotiation, mediation, and all that.
All right.
Yes, thank you.
Thank you. Barista Uche.
Okay, arbitration is one other model of alternative dispute resolution. Now, it is many of the times when you look at contracts, when you go through contractual agreements between parties, you find the arbitration clause there, where they say that where both of them agree that they would resort to arbitration before going to court, or they would not even go to court, they would rather settle through arbitration. So most times too, the court might decide, where the court finds that yes, you rather go through the arbitration process to settle your dispute, the court might send you to decide that you should go for arbitration. Now, for instance, in Lagos, we have what we call the Lagos Multi-Door Courthouse. This is a bundle of options open to parties to a dispute where they can settle their matters outside of the courtroom, outside of litigation. So you can, depending on the nature of your matter, you can choose any of these models and settle your matters without actually resorting to litigation. Now, many times as well, in the course of the dispute, even when the matter is already in court, parties can themselves decide that, yes, we do not want to continue with litigation in the open court. We would rather settle out of court, and then they could resort to either arbitration or even conciliation or mediation or any kind of model they wish to adopt.
He also talked about the court assigning sometimes retired judge.
Yes, there is an arbitration judge. Arbitration is more, it's not as formal as these other models. It's more complex. It has its own rules. There is a judge who oversees this model, and we'll look at it very critically tomorrow.
Okay. All right, so the caller, perhaps you need to listen in again tomorrow on the program. All right, then 081-8999-1011. Call us up right now if you have questions to ask. Even if your questions are not pertaining to the topic for today, feel free to call in and share your thoughts with us. Hello.
Hello.
Good morning.
Good morning, Probono Chambers. Good morning. My name is Pascal Paul from Papi.
Okay, Pascal, we're listening.
Please, 2 short questions for clarification. 1, what are the differences between a judgment of a court and a ruling of a court?
Okay.
Then 2, can a ruling of a court be appealed in a higher court? That's all. Thank you, sir. Thank you, madam.
Thank you very much, Pascal.
Yeah, that's it for Papi.
Oh, okay.
Okay. When a matter is in court, many times in carrying out that matter, there are issues of conflict in the process or in the procedures, or where parties can have not the final determination now, right inside the matter. Let both of us appear in court. In prosecuting that matter or in handling the matter, both of us might not necessarily agree on one particular point. If, for instance, let's say we have a tenancy matter in court, and in the final determination, I have asked for my prayers. I have made my claims before the court. Now,
which of the questions are you answering right now?
I'm answering the difference between ruling and judgment.
Okay.
Now, midway, we could have a disagreement on a particular point. Now, we would now canvass our arguments on that court and allow and on that point rather, and allow the judge to make his ruling on that particular issue, which is not the final determination of the matter. I don't know if I'm making sense. Okay. Now, judgment, however, is the final decision of the court on the matter. That is where the court makes its findings, after everything, makes up its findings and makes up its mind and arrives at its final decision on the matter. However, a ruling is a decision made by the court in the middle of the matter based on a particular issue of dispute by the parties. However, the judgment is the final decision of the court on the entirety of the matter. And yes, you can appeal a ruling. Where you find out that you do not agree with the decision of the court or the ruling of the court on that particular issue of dispute in the course of the litigation, yes, you can go on appeal, get your decision from the higher court, and come back to the trial court and continue with the entire process.
Okay. I hope he really got that. 08189991011. I think we have room for another call at least. Hello?
Hello.
Good morning.
Good morning. Good morning, ma'am.
Morning, welcome. What's your name?
My name is Onome.
Adamu? Onome?
Yes.
All right, welcome. Please go ahead.
I have a question. My uncle just got released after being detained for over 2 years, awaiting trial. And when he was discharged, the lawyer handling the case said they should be taken again, but he pays a certain amount of money. Does the lawyer have the right to say he should be detained? That's my question. Because right now we don't have the money he's asking for.
Okay. You get the question? Did you get the question? No. Hello?
I'm listening.
Okay, can you repeat yourself again, please? You said your uncle was...
My uncle was arrested and detained for over 2 years.
Okay, and detained for over 2 years.
Awaiting trial. Okay?
Okay.
Then finally the court released him on bail. But they discharged him, he wasn't on bail, they just released him like that. Then the lawyer handling the case said they should still retain him. He didn't say it in court. He told the warder to still retain him.
He told who?
I'm listening.
You said the lawyer handling the case.
Yes,
that's his personal lawyer.
Personal lawyer, yes.
He said they should do what?
That they should retain him again. They should lock him up again until he pays a certain amount of money that he mentioned.
Okay.
And right now we don't have that kind of money. My question is now, does the lawyer have the right to do something like that?
Okay. And who is it that he was saying? Is it the police that should detain him again, or where? Or prison?
Prison.
Okay.
It means he was not granted bail?
Hello?
He wasn't granted bail. He was just released. Yes?
He wasn't granted bail. He was just released.
Okay.
Because there was no evidence that he committed the crime.
Okay.
There was nothing inciting to the crime.
He has been awaiting trial 2 years, and then he was just released without
over
3 years. Okay, because there was no evidence of his guilt.
at all.
So does his lawyer, have any right to say, come on, detain this man
Yes,
again?
that's the question I'm asking now.
Okay, and how much is he requesting?
I don't really know, but you just told me.
Let's just say, okay.
But that you don't have the kind of money now.
Okay, but his question is, does the lawyer have such right?
The lawyer is asking for his fees.
The lawyer is asking them to pay a very high amount of money, high sum of money to for bail.
But the uncle has been.
Okay, I don't
get.
Thank you for your call. I think
I don't get the scenario
Barrister
exactly.
Uche, it is the lawyer that is asking his client now to pay a large sum of money as bail. Mister, am I saying it correctly?
I think that's it.
Okay. Your uncle's lawyer is asking for money for bail.
No, he's asking that my uncle pay him a certain amount of money.
What is the money for?
I thought you said
for over 2 years. He would have at least allowed him come out. Then they talk about money.
Okay, the money he's asking for now is not for people, because you said he said he should be detained again. So it's not for bail. The money he is asking for is not for bail. It's for his own fee.
Now, yes, for the services he didn't render.
Okay, so because if you are unable to raise that money, he is now saying that your uncle should be detained again.
Yes, as I'm talking to you now, my uncle has been there for about a week now, without anything tying to any crime.
Okay. All right. Thank you for your call.
Okay.
All right. So, Barrister Uche, let's say, for instance, because I don't know what's happening. You don't seem to understand the situation still.
I don't, and I'm trying to understand why. I'm trying to.
Okay, so you are my lawyer.
Does it mean the man has been released from detention?
Yes.
And then his lawyer asked him to pay a certain amount of money.
Yes.
He couldn't pay the money, so the lawyer made them arrest him a second time.
That's it.
Wow. This is very.
Obviously, they've taken him back to prison. That's what he's saying.
Oh.
So it's actually his own fee that he wants paid, not any bail money. His uncle was never granted bail, but then after 2 years, over 2 years, there was no proof. So, come on, go. That was exactly what happened. And the lawyer now, being that he hasn't received any money, from all of his services, is saying, okay, Oga needs to be detained again until and unless he is able to pay this sum of money. And they do not have that amount of money. So what can they do? Does the lawyer have such right is his question.
No.
But then it has happened. So what can they do?
Wow.
It's a tough one. Perhaps we would...
I would rather want to...
Okay, Mr. Caller, do us a favor and call back tomorrow. Same time, possibly, then we would give you an idea of what to do.
Yes, because this is it's strange,
kind of like.
Yes.
Yeah, but these are the strange things happening in the country. So, but then that's just what we would do, I guess. Mr. Caller, man, sorry, I forgot your name just now. Please call back tomorrow, still in the 10 o'clock hour, and we'll see what we can do to address this situation. All right, and Ms. Uche, that's the much we're taking on the program today. Any further comments?
Well, like I said, it's very advisable that parties resort to alternative dispute models, any one of them, before going to court, because of course it has a lot of advantages that will be of immense benefit to whatever issues there are in dispute, and of course to the parties. So it's important that we focus more, or we try as much as possible to utilize these models more often.
All right, that's our in-house barrister Uche. Many thanks to you for being on Probono Chambers today. And to those who called in as well, thank you for your time. Tomorrow we'll make a return the same time, that is the 10 o'clock hour for Probono Chambers. I am Ruth Usman. Do stay with us. I will be back at in the 11 o'clock hour on Media Lab.